Let's get into it. It's crime o'clock, yeah, feel that sound. Typically unique when the truth comes out. Tick-tock, won't stop, let the facts talk. Pull up real close, yeah, it's crime o'clock. Clock, clock, yeah. Typically new, neon signs glow, brick wall behind me. Headlines loud, but they never define me. They rush the story, skip the proof. I slow it down, let it show the truth. Files on deck, read every line. Timestamps matter, so does time. If it don't fit, I don't force the frame. Ask one question, whole story change. No fear my voice, no need to shout. Paper speaks when you read it out. If the math's off, I'll circle twice. Truth ain't loud, but it ain't nice. Yeah. Read it again. It's crime o'clock, yeah. Feel that sound. Typically unique when the truth comes out. Tick tock, won't stop. Let the facts talk. Pull up real close, yeah. It's crime o'clock. It's crime o'clock. Read it again. They sell a narrative if I sell receipts. Courtroom quiet, but the pages speak. Word for word, no added spin. Let it stand, yeah. Let that sink in. Screenshot save, timeline's tight. Missing pieces keep me up at night. If they say alleged, I say why. If they say case closed, I say try. No rush here, we do it right. Truth don't bend for the likes of hype. If you came for noise, you're in the wrong spot. This is evidence, this is crime o'clock. Clock, clock, clock. Stay with me. This isn't background noise. This is pattern recognition. This is documents. This is crime o'clock. It's crime o'clock, yeah. Feel that sound. Typically unique when the truth comes out. Tick tock, won't stop. Let the facts talk. Say it with me now. Crime o'clock. It's crime o'clock. Typically unique. It's crime o'clock. Yeah. If you're here, you're early. If you're listening, you're paying attention. Show starts now.
Welcome back to Crime O'Clock on Typically Unique. It's great to see everybody today. And we are here to watch the live hearing from Moscow, Latah County, 2nd District Court, I believe, EWU Media, LLC, suing the city of Moscow and Moscow Police Department over their not fully releasing the documents that they had requested. And I was happy to find that they are addressing the over redactions. So I cannot wait for this. Cannot wait for this. Hello, hello, Tan Kim. Thank you. I haven't been in the sun in a few days. It's supposed to be sunny today, though, so I'm excited for that. Hey, Astastic. Hi, Sweet Pea. Mystic Sin. Hello. J-Bean. Jen 7S. Hello, hello. Blue Devil 95. How are you doing today? And before I forget, hey, Mike. Before I forget, mods, we're going to get together tonight in voice if you are available around 6 p.m. So there's a message in Discord. If you can let me know, I'd appreciate that. And speaking of Discord, just some updates. We have a summer song playlist that we have created. I don't know if it's still available. We were going to keep it available for a short time, but then I'm turning that into a YouTube playlist. So we just had everybody put a favorite summertime like song. That was fun to collaborate on. And then we also have a cluck and debunk section. And there was a poll in there to pick one thing from the Idaho 4 case that we would want to provide evidence for debunking it, which I think is awesome. So what else? Updates. So shout out to Miss Rachel. If you know, you know. No, I'll give you the backstory. So Miss Rachel, is the baby toddler TV channel. She came after my kids were little, so I never got to watch her, but I know she's amazing, and babies and infants love her when she comes on the screen. But she stood up and made some statements, I guess, about Nolan Wells, and she's also done things for the children that have been in the I'm going to call them concentration camps. I'm sorry. The internment camps that we have here in the United States. I can't not say it. I'm sorry. So yeah, shout out to her. And then prayers for Perez Hilton. Oh my God. I hope none of you witnessed that last night. I did not. Your grandson loves her. Astastic. Yeah, all my great nieces and nephews love her too. Yeah, he had a violent emotional event last night live on TikTok, and I guess it was horrific. I tried to look for some updates, and it looks like he is in the hospital. So your coworker saw it. I guess it was, I just saw people talking about it. I didn't watch it. And it wasn't available by the time I found out about it anyways, but man. Yeah, that's what I heard. It looked like a scene from the movie Carrie. Yeah. Luckily, what I heard was that the people on the live were immediately calling 911, reporting it before it got taken down. So, it's one thing to take it down, but oh my God, you want to get somebody help, right? Like get them help. So yes, sweet pea. Yes, that's what it was described as. Yes, woke up 1984. Good to see you today. Hi, One Can Leanne. I hope I said hello to you. That's traumatic. That's traumatic to witness something like that. Yes. I have some comments of the day. The people that shared them aren't here yet, but that's okay. Let them know when you see them. Comment of the day, you guys. This one cracked me up. So yesterday we were talking about Mason Bangman because of Martha Smith's interview and her literally saying his name. And if you watched his arrest video from Boise, Idaho, when he got arrested, he was the whole ride to the police station, which was not very far. He kept saying, "Can I get unarrested?" So Sleuther 75 is coming in with the comment, one of the comments of the day. Mason Bangman will always be the any chance I can get unarrested guy. But what's funny is that Mason Bangman said, "Hold my beer," and came back with being Barkman, dog bark man. So he's got some good ones. All right. And then yesterday, when Michelle gets in here, Michelle F22, she gave a donation yesterday, and I did not see it until the live was over. I apologize, Michelle, but she was saying that, do you guys remember I believe it was a Facebook page, right? And it had that like eyeball, didn't it? And it said, "I see you too." But she's saying C was SEA, like for Seattle. I did not know that. And that's where Caden was. Were they in Seattle? I thought they were in different cities in Washington. I don't have that information on the top of my head. Caden's friend was in a town, I don't think with a common name. And then they were going to... Is Luther here? Is Luther here? Can we just discuss the cops had 12 suspects? Oh, you mean on that list? I have that list. You know who's not on that list? Mason Bangman or Nick Mowich, the guy that, you know, had scratches and cuts, and it was so bad that a nurse had to report him. Are you talking about these suspects? Yes, Luther, I had here. Let me show you. I don't see her. Why don't I see her? Any chance I can get unarrested? We need to put that on a t-shirt. Can I get unarrested? You're the comment of the day, Sluther. And then I said, Bangman said, hold my beer, and became Barkman. Oh my God, that's funny. That's funny. Okay. Enough of that. Enough of that. What time is it? 11:39. All right. So I'm always nervous when I'm showing a hearing because, where did I put it? Here. So I know I went to the right court site, and this was the link. Honorable Megan Marshall. This is her live stream, so we should be good to go. I'll get the... Oh, it won't even let me do anything right now. So, you can't see it. Unlike last time, Bark Boy. You got it. Bark Boy who wants to be unarrested. The last time there was a hearing for EWU versus the city of Moscow, it was joined by Zoom. So it was a little complicated because coincidentally, they forgot one of the letters or digits at the end of the Zoom code. But we figured it out anyways. I think Jules ended up calling the courthouse. Like, it was crazy. This time they're live streaming it. So it should be on their Facebook page right here. Not Facebook, YouTube channel right here or whatever. I mean, this is not... Talk correctly, Kim. This is Idaho Judicial Branch court live streams. So, but I think it runs through YouTube. You guys are still talking about the barking. Oh my God. You know what we need? We need a list of like hilarious comments, sayings that have come out of this case. Like, that's right up my alley. That is something we can put in the Discord. We need a channel for that. There's been too many. Excuse me. If you guys could share this live out, that would be great. Let me see if I put it in the Discord. I'm going to do that real quick. What am I doing here? I don't want that. I'll do it on my phone. It's faster on my phone. Okay, so I'm going to catch you guys up to speed a little bit. We'll start with this. So the last time there was a hearing, these were the players. Okay. So up in the left-hand side is the judge, Megan Marshall. She will put on a good front, and she will talk like she's impartial. That's what she did last time. I almost fell for it. And then you will subtly hear a turn. And that's what happened last time. She seemed very middle of the road, very fair. But then when it comes to make a decision, in my opinion, she'll side with the state. That's my opinion. Those are my predictions. So we'll see how that goes. But that's her. And then in the middle, there's a black box. They did not have a court clerk the last time. Everybody had to agree to that. I guess they were super busy. So that's just a black box. They said they would have one this time, though. On the upper right-hand corner is a representative from EWU, and her name is Amy James. So she's actually from that media group. She works there. I mean, we'll see. I mean, the law is the law, right? I mean, she can't change the law, and I think they're breaking the law. So we'll see. Okay, Leander James underneath the judge, glasses, gray hair, beard. I believe he is the representative for Maddie's mom. So they were interveners. That means her mom has a vested interest and a concern about information being released. So he didn't really speak too much last time. In the middle is Katie Brereton. I don't think she spoke too much. I think she's representing the city of Moscow. The lead guy for the city of Moscow is Zach Jones. To the right, the younger guy with the suit, tie, light blue shirt. And he was hilarious. He literally said, "We're just winging it." I was just winging it because if I can remember correctly, I was looking for my notes. This is the only notebook I haven't looked through yet. Let me just double check. The EWU filed their lawsuit, okay? And then you're supposed to get a response. And I don't think so the city's response was dismiss the case, or you don't have a case because you don't have a business here in the city of Moscow. That was their response from my memory. EWU was like, we don't need to have a business established in the city of Moscow. But we'll do it anyways. If you set out a hoop, here's a hoop, you want us to jump through it, we'll do it. We'll go ahead and do it, even though they technically should not have had to do that. Because if you think about it, if Dateline requests records, do you think Dateline is setting up a business in the city of Moscow? No, they are not. So that was ridiculous, but they did it anyways. Moscow still did not respond. They never did their official response. And that's when he said, "Well, Judge, we're just winging it." I cannot believe those words came out of his mouth. Crazy. Oh, sorry. I'm turning my volume down. I'm going to get this shared out. I think there's people in our Discord that might not even know we're on here. Get over here, peeps. Get over here, peeps. We can do both. We can chat in Discord and we can be on the live. Okay. One of the biggest controversies on this panel of people, in my opinion, is the lady in the lower right-hand corner with the gold yellow circle behind her head. And that is Mia Batista. And I think that's a conflict of interest. I do not think she should be a part of this hearing. She is literally the attorney who approves or disapproves the FOIA requests. And she's sitting in these hearings. You're good, Jen. You're good. There's so many other creators on right now. I think chat will be okay. You're good. So I think that's a huge conflict of interest. I would think that EWU knows that. They didn't raise a concern about it. I think EWU is very confident. And here's something you guys need to, she is the problem, Sweet Pea. She is the problem. Maybe you want the problem to be there. Maybe you want the problem to be there so you can call them out to their face. I mean, go head on. I don't know. What was I going to say? Oh, EWU. If you guys don't know, they are a huge LLC. They have multiple channels. If you go to their website, they have, true crime, just body cam. They have like just a body cam channel. They have, I'm just going to make up examples, things like, police chases. They have just 911 calls. They have, very specific channels like that. And they have many. And they're not all just true crime, right? Yeah, a lot of you have been watching them for years. Yeah. Well, they get their content from records requests, okay? And hi, Deb Tutterow. They do this all the time, all over the country. They know records request FOIA laws. They know Freedom of Information Act laws. So doesn't mean they're going to win. I think Idaho will probably be one of their toughest battles, but we will see. All right. So the last person on the bottom left, the light blonde, Kirsty Kennedy. Kirsty Kennedy. She's the attorney for EWU. So she's the one you want to be watching. It's probably going to be Kirsty Kennedy and Zach Jones. I would expect them to be speaking the most. Not sure. Hi, Karmic Retribution. How are you today? Awesome video you put out. Oh, they had exploring videos. That's cool. Hi, Song of the Siren, Jenna. Now, also today, we should be hearing their arguments. Okay, so we have a few minutes. I'm going to pull up. Kathy's Indie Zone had their actual complaints, which was amazing because I was concerned. I actually emailed EWU's attorney, you guys. Sorry, I don't know what's wrong with my throat. I didn't bring a drink in with me. I'll go grab one once the hearing starts. Yeah, Lala was awesome. I think I'm still recovering. I emailed EWU's attorney because I did not hear them talk about redactions and the costs that they are charging people with the records requests. Okay. So I never got a response, and that's fine. I didn't expect a response. I just wanted to make sure they knew what was going on to us peons out here. So let me see. Can I make this bigger? Open image in a new tab. Let's see if this works. Oh, it is working. All right, you guys. Can you see it? Can you see it? All right. So this is, and let me keep an eye on the time. We got 7 minutes. Okay. So this is what EWU has requested. Let me make sure I'm not in top chat. I feel so bad because I know I missed people yesterday. Oh, Sluther75. I know Lana was trying, told she couldn't. Whatever. We could file our own lawsuit. Okay. So EWU asked for the DoorDash driver, Molly McMichael's interview from November 23rd. And then they cited, where it comes from, that they wanted the cognitive interview audio. They wanted the surveillance clips from King Road and Queen Road cameras. They got the timestamps, and it's from Supplemental 104. Here's the response they got. All requests for FBI created records must be submitted directly to the FBI. MPD record is duplicate record. And I think EWU is going to say, I call bullshit on that, and that you are in charge of this investigation and you have the records and you need to turn them over. How many of you in the chat got told, oh, that's FBI, we can't turn over FBI stuff? Yes, Mystic Sin, I guess they probably had a deadline for sure. Then they asked for the Pullman PD body cam from September 4th, Axon Flex 2, where Molly McMichael mentions seeing Bryan. What? Pullman Police Department body cam. Oh, where they were interviewing her. I got you. We already have that stuff. Like, they're asking for stuff that we already have. Isn't that interesting? Like, that's how much that people don't know what's going on here on YouTube. And by the way, I saw Jules calling out Netflix so bad because I guess they were promoting their show like never before seen footage. And like, we've had that footage on YouTube for like 8 months. I made sure that this live did not have ads. So if you're getting ads, it's not for me. I clicked no ads. Sorry about that. I will tell you if I have, usually I put like ads to be on like low amount, like very low amount. But today I clicked no ads because I knew we were going to be watching a hearing. It's not my fault. Yell at YouTube. Yes, Wade Bird. And like Jules' point was, either Netflix paid like $30 duplication fee, or they just took it right off the channel. How shady is that? And then didn't even give credit, and didn't help with the cost. Come on, Netflix, help us out over here. Right? Someone with a conscience needs to hear all of this. Okay. So again, the response that was given was that all these requests for Pullman need to go directly to Pullman, not from us. And that's basically every response that they put in here. Okay, so we got a couple minutes until the hearing's supposed to start. So real quick, they were asking for neighborhood surveillance. So all the places in the documents where they were saying the car was cited, they wanted all of that. They wanted, this would be interesting, they wanted a DVD transcription of the jail calls, Bryan's phone calls and Kohberger calls. And those are cited in Supplemental 228. And they wanted an inmate housed next to Kohberger jail call with his mother. All right. Then here's the one I was looking for. Way down here at the bottom. This is the one I was looking for. Witness interview videos produced by Moscow. Like, boom. They just wanted all of them. Like, just give me all the interviews. And they said here in the middle, here, records provided with improper redactions. Witness interviews blurred, redacted beyond what EWU contends was required by the permanent injunction. So I cannot wait to hear them speak on that. That's going to be awesome. All right, let me see where we're at here. Is it going? Live. I'm going to have like, make sure, I think I put it at the bottom. This one. Court live streams. Okay. I saved the link here. I'll show you. So current cases, court live streams, state of Idaho. No, this is not what I want. Let me go back. Close that. I have Washington. Here, this is what I did. I did Megan, Marshall, Moscow, Idaho. Right there. No, that's not the right one. U.S. courts. I don't think that's it either. Nope. Court contact information. It's got to be in here. Home. I'm pretty sure I already have it set up on the right page. We'll make sure. So we're waiting for them to come on. All right, other people have the same thing pulled up, so I'm not freaking out yet. I'm messaging Lana in her chat. I said, girl, I'm on the same page. Okay. I always get like, afraid I have the wrong thing. I wasn't sharing it anyways. Let me show you guys. So let's share the screen. Here we go. They're usually late anyway. So we got volume. I can make it full screen. I keep hitting play. Keep hitting refresh. Oh! That's my ringtone. That's my ringtone. Your 2 weeks notice. How do you connect? You got to get to their website and go to their court streaming. And I know I have it, but I get like nervous jitters. Let me get back over to our show. Please make sure you're hitting that like button for me. Aw, thanks, One Can Leanne. Okay. Let's see. I'm going to refresh again. I have the website saved on my phone. So let me do this. I'm not really like stressed out because it took a while last time for them to start. So, okay, not that one, this one. Okay. Here we go. I will send myself the link, copy the link. I'll show you guys how I do this. This is what I do because for me, a lot of things like sending myself links and screenshotting and stuff like that, it's easier for me to do it on my phone. But then when I'm on a live, I'm on my computer. So what I do is I have a Google Doc and I'm going to put I'm going to put Lata live stream. And I just link it on this document, and then I can pull the document up on my live and click the link. And then I can share it with you guys. Jules is live. Let me refresh.
Or preliminary matter is that the city did file a respondent's request and records log. Subsequent to that, Ms. Kennedy, on behalf of EWU, filed in her reply a table of records at issue. The records at issue that were filed by Ms. Kennedy appears to be, I guess, less than what was included in the respondent's request and records log. And I'm specifically looking at the last EWU request, which was August 28th of 2025, and which was denied or responded to, by the city on September 15th of 2025. So Ms. Kennedy, I guess on behalf of the plaintiffs, are you essentially conceding or saying that the only records at issue are those that are listed in your reply, or are there still some records that EWU had initially indicated in its August 28, 2025 request that have not been received that you still wish the court to address in its overall decision?
Your Honor, I think we can safely say that what's in Appendix A and B is what we're requesting the court to rule on. There are some documents that the city put in their log and that were in the August 28th, 2025 request that may or may not have payment issues related to them. And so I think those are things that if it's just a matter of EWU making payment for those items, I think that Zach and I can work that out. And we can work that out with the city, but we just want to make it simple for the court. And so, yes, you can look at the Appendix A and Appendix B, and those are the records that we would like the court to rule on.
All right, thank you. Mr. Jones, are you in agreement with that at this point?
Your Honor, I'm fine with that. It does kind of, I guess I was going to, and I will include in my oral argument that up until this point, we really didn't really know what was being requested, and it hasn't been narrowed down to this small amount until the eve of the hearing. And so part of our argument is going to be that we weren't sure what exactly was being requested, and that is a significant part of why we kind of got to where we are. And so I'll incorporate that into my argument. But with respect to the fact that this is all they're requesting, I mean, I guess I'm fine with the court narrowing it to just that, as long as we can incorporate that other aspect of our argument.
Okay. All right, thank you. Mr. James, anything to add on that?
All I would add, Your Honor, is I am pleased that petitioner did narrow it down. This is very helpful, and I think it helped to move the process forward.
All right, thank you. All right, with that then, Ms. Kennedy, I will start with you and you can present argument at this time.
Thank you, Your Honor. This case is one of the most significant criminal investigations in Idaho history, and Moscow led the investigation with assistance from other agencies. Now, these other agencies may have produced certain investigatory records, but these records were undisputably used, retained, and compiled by Moscow, and they became Idaho public records. So they must be disclosed unless an exemption applies, and Moscow simply hasn't proven an exemption. They have raised essentially 3 exemptions, which is custodianship, foreign law, and privacy, and I would like to go through each of those exemptions in turn. The first exemption that they've raised is custodianship, but the word custodian in the statute is not an exemption unto itself. And the Idaho Conservation League case, which we cited in our briefing, explains that the identification of the proper custodian has no bearing on whether the public records are exempt from disclosure. The legislature didn't intend custodian to be its own exemption. Custodian is simply the person within the agency who has certain administrative responsibilities for the records. But even if we interpret custodian as its own exemption, the city certainly had custody and control over these documents and is their custodian. They don't dispute that they have custody of the documents, which I think we can agree upon is some kind of physical possession. But they dispute that they have control. And the dictionary defines control as to exercise restraining or directing influence over or to have power over. And they certainly had control over these records. They requested assistance from other agencies, so they essentially requested that these records be created to begin with. These records were then provided by these assisting agencies, the FBI, Pennsylvania State Police, etc. And those were provided to Moscow to assist it in its investigation. Moscow has stated in its declarations that it was the lead agency for handling physical evidence. And that evidence went into their files, into their evidence log. This information was compiled into their files. And our statute related to investigatory records is quite broad, and it defines those records as anything compiled into the agency's files for law enforcement purposes. And these records were used and retained by Moscow, which makes them public records. And presumably these records were given to the prosecution to prosecute this case, which presumably would give them to the defense. And we can assume that some of these records, or maybe all of them, were part of the probable cause to arrest and prosecute Kohberger. So they underlie Moscow's activities as a law enforcement agency and as a governmental agency of Idaho. So they controlled these records, and every record, or I think most records mentioned in Appendix A, are referenced in a publicly available police report. And that's what that SUP number means, is that refers to the police report in which the document appears. And so all these documents were used in some way by Moscow Police Department. And so because of that, we believe that they were therefore controlled by Moscow. And these documents are a major part of the Idaho criminal investigation. If, for example, you take the Kohberger interrogation video, that is a clear Idaho record. Brett Payne from Moscow PD flew to Pennsylvania along with a member of the FBI to interrogate Kohberger in Pennsylvania. My understanding is that that was recorded by Pennsylvania law enforcement at their facility. But merely because it was recorded in Pennsylvania, in a Pennsylvania facility, doesn't somehow transform that into a Pennsylvania and not an Idaho investigatory record, particularly when Idaho law enforcement is there taking part in the interrogation. And so these records, this is a key Idaho record, and many of these other records that we are seeking are key parts of the Idaho investigation. And it would be poor public policy to say that these key criminal investigatory records that were requested to be created by Moscow, used by Moscow in their investigation and prosecution, were then exempt from disclosure to the public merely because they originated with one of these assisting agencies. The public has a right to know about how law enforcement conducted this investigation, and failure to disclose this information just invites unfounded speculation into this case. And so we believe that these documents should be disclosed because Moscow is the custodian and it has custody and control of these records. So the next exemption that's been raised.
I'm just going to interrupt you there for just a minute, kind of taking the pieces in part here. So in reviewing your briefing, but hearing your argument today, are you saying that, taking, for example, the example you provided about the interview. So is it EWU's position that if Moscow or some law enforcement part of Moscow, whether it be the city of Moscow or any agency related to Moscow, if they helped in any way in assisting or took part in creating the record, then those are the ones in which they should be able to disclose? Or are you also extending that to, for example, taking your example of a Kohberger investigation, if that exists, I don't know, but taking your word for that, if it was just Pennsylvania law enforcement and the FBI who interrogated him, Corporal Payne was not there at all, but yet that record is in the possession of Moscow because it was shared with them. Is it EWU's position that they still must then disclose that, even though it was created and the Moscow had no part in creating that?
Yes, and I think that's because the Idaho Public Records Act is very broad. It says that public records are anything used or retained by the city, and the investigatory records exemption is arguably even broader, and it says investigatory records are those compiled in an agency's records, law enforcement records, just to summarize it. And so if it's that broad, that suggests that information compiled by law enforcement, regardless of who created it, becomes an Idaho public record, and it's subject to disclosure unless there's a particular exemption under the statute. So even if it was an FBI video, an FBI interrogation, so long as Moscow is using it, retaining it, compiling it into their records, it is an Idaho public record that's subject to disclosure. My example for the Kohberger interrogation video was merely to just show how absurd this seems to me, that this was actually an interrogation that appears to be conducted by Moscow, but because it happened in another state, or it might have been filmed by Pennsylvania, that that the public does not get to see it.
Right. Thank you, Ms. Kennedy. And then I'm going to follow up with a question that I think you're probably going to address in this next part, but with regard to the next exemption concerning other law and how it may apply, whether it be federal or other state law. And my question is this, is that if EWU were to go to Pennsylvania to get the Pennsylvania record, and Pennsylvania law is more restrictive than Idaho, but Idaho happens to, an agency here in Idaho happens to have that record through that law enforcement sharing process, then my understanding it would be EWU's argument that they should be able to come to Idaho, even though they were rejected in Pennsylvania to get that record that was created by Pennsylvania. They should still be able to come to Idaho.
That's exactly right.
And can you talk about, if any, a chilling effect that might have upon law enforcement agencies in being able to share records and investigations like this?
I think that's possible. But we have a policy in the state of Idaho that records are subject to disclosure unless there's a statutory exemption out there that expressly exempts the document from disclosure. Pennsylvania, they have a different public policy, apparently. They keep a lot more things private or confidential. Idaho favors disclosure. Now, Pennsylvania could, I kind of doubt that law enforcement says, well, I wonder if I'm going to not help Idaho or not give Idaho information because the public of Idaho might see this. And that seems to me that would be unlikely, that Pennsylvania law enforcement isn't going to assist because somebody in Idaho might later get the record. I suppose that could happen in certain scenarios, but our legislature has made the decision that we're going to favor disclosure of records. And the legislature, could, maybe the court decides that we get the Pennsylvania records and the FBI records, and later the Idaho legislature could say, well, we need to do something about this and create an exemption for records received from outside agencies. But they haven't done that yet. They've decided the public policy of the state is going to favor disclosure. So I see that as a legislative problem and not a problem for the court. I don't think the court can create an exemption that's not there to serve a public policy. And I think it's a speculative public policy because it doesn't seem to me to be logical that law enforcement from another state wouldn't help, because several years down the road when the case is done, a record might get out. If anything, the law enforcement, I think, that was involved in this case should be proud of their work and should want the public to see what was done here and how the investigation was conducted, because it was, to me, as an outside observer, there was, this was ultimately a successful prosecution. And so the public should be able to see those materials.
Great, thank you. You may continue.
Thank you, Your Honor. And so the next exemption then would be foreign law, and that's state and federal. And state law appears in Idaho Code 74-1041A. And when we look at exemptions under the Idaho Public Records Act, as the court is aware, we narrowly construe any exemptions, and that includes the meaning of the word state. And so, as we've argued in our briefing, state law means Idaho. It means things like the attorney-client privilege. There are other areas of state law that exempt certain documents. And so state law doesn't mean the law of any other state. It means the law of Idaho. And really, if we if we interpret state law to mean any state's laws, that's really an absurd reading of the statute, that somehow Pennsylvania or Washington law would apply to Idaho agencies and Idaho records. But even if we can interpret state to mean any state's records, the Pennsylvania and the Washington laws that have been cited only apply by their terms to their own agencies. They don't apply to Idaho or outside states in making public records determinations. Similarly, with federal law, the city's most recent brief was the first time we actually understood what federal law they were claiming an exemption under, and that turned out to be FOIA. But there's a Idaho case that's directly contrary to that position, and that's Magic Valley, which we cited in our briefing. And that case states that the FOIA only governs the disclosure of public information by authorities of the government of the United States. It doesn't purport to govern disclosure of information by state agencies. And so that's exactly the argument that the city is making here, that FOIA somehow governs Moscow and governs the state agencies, but Magic Valley dispenses with that and says FOIA only applies to certain authorities of the United States. There are federal laws, for example, HIPAA and FERPA, that apply directly to states. So for example, if I went and tried to get information about a patient from a state hospital, or I tried to get educational records from U of I would get an objection under HIPAA or FERPA for sure, because those exemptions actually apply to the state and local agencies. But FOIA is different. FOIA doesn't work that way. It only applies to the government of the United States. And so a federal law, or at least the particular federal law cited here, does not exempt these documents. So moving into the third exemption that they've raised, which is privacy. And we cited the Wade v. Taylor and the Hymas cases. And those cases say that there's no categorical exemption for investigatory records. The city has to show for each record that there's a reasonable probability of harm. So here they would have to show for each record that there's a reasonable probability of an unwarranted invasion of personal privacy, and we just haven't seen that here. They need to produce some kind of evidence of that, and they haven't done so. And we provided, as I mentioned earlier, Appendix A, which lists the records that have not been disclosed to EWU. I don't know if the city is claiming a privacy exemption of some sort over those records, but we have not seen that to date. So assuming that they're not claiming a privacy exemption over those records, and we're just really talking about Appendix B, which is the body cam footage, they have asserted a privacy interest over those records, but the scope of that privacy interest has already been decided by the court in the permanent injunction. For example, there are witness interviews that have been blurred, and we understand that the court has already decided that those should not be blurred. The bedrooms are probably overly redacted, and we don't want to tread upon the victims and their families' privacy in that regard, but the court's order was narrowed to the death scene and the surrounding area, is my understanding of the order. And the bedrooms appear to be overly redacted. There are more bedrooms redacted than there are victims, so to me that suggests there's over redactions there as well. So we've requested for those records that the court conduct an in-camera review and order certain redactions to be removed as necessary. And I would also like to mention that the city's briefing focuses, well, they've focused on EWU's business model at several different times in the course of this litigation. But EWU's business model is really irrelevant. In Wade v. Taylor and in other cases, the court has made clear that the requester's motivation is really irrelevant for requesting the records, and agencies aren't supposed to discriminate based on who the requester is. And so any sort of reference to EWU's business model is just irrelevant to this case. So with that being said, none of the exemptions that they've raised, custodianship, foreign law, or privacy apply. And so these records must be disclosed because no exemption has been proven. And in my briefing, I also did mention attorney fees because there wasn't, to me, clarity in the statute in terms of when we request those. So I can argue that now, or I can wait later, depending on the court's preference. But unless you would like to argue the attorney fees portion, I don't have any further comments for today.
Thank you, Ms. Kennedy. You can go ahead and argue that now, just so we have it, and then I'll hear from Mr. Jones.
Okay. We did request attorney fees under two separate provisions. I believe it was 74-124 and then 74-116. And 74-116 is kind of the typical attorney fees provision for public records requests, and it mentions frivolousness. But we did also cite Idaho Code 74-124, that's the investigatory records exemption, which has its own fee provision. And it doesn't require a showing of frivolousness, it just requires the court's discretion to award fees. But we listed a number of reasons why we believe an award of fees would be appropriate in our briefing. So the court can reference those, but I think something that stands out to me today is that every argument that the city has made related to an exemption is contrary to established authority in some way. The custodian exemption that was raised is against the Idaho Conservation League case. The foreign law argument that was made is against the Magic Valley case. The privacy argument that was made is against the permanent injunction. And of course, you can make arguments that are, for reversing authority or for changing prior authority. But there was no argument made about why these cases or the court's prior order was wrong or was subject to challenge. The city just sort of argued these things anew. And so because of that, in addition to the other issues we've listed in our briefing, we believe an award of attorney fees and costs would be appropriate. So to overall summarize, what we're requesting is disclosure of the documents in Appendix A, an in-camera review and removal of redactions consistent with the permanent injunction, which would be Appendix B, and then our fees and costs. But thank you, Your Honor.
Thank you, Ms. Kennedy. Mr. Jones, response?
Thank you, Your Honor. To begin with, Idaho Code 74-102 sub 4 requires that the requests have enough specificity to allow the public agency to determine what the records are and what the records being sought are. It does not require the public agency to engage in any sort of investigation regarding what exactly the petitioner is requesting. And in Wade v. Taylor, which is cited by the petitioner and for other reasons, the main holding in that case is actually that the records that are being reviewed by the court are reviewed at the time of the request, not at the time of the hearing. And that's kind of what we have right now, where we have a much narrower review of the records that are being requested, whereas what the city's been really kind of having to work through is the information that was attached to the declaration of Amy James on March 30th to determine what exactly the records that the petitioner was requesting. And so until the Appendix A came, which is respectfully just too late, the city really didn't know what records the petitioner was requesting, and they lacked specificity. They were ambiguous and they couldn't be met with reasonable effort.
So Mr. Jones, I do want to ask though, in the respondents in the city's request and records log, and that's if we look at the time of the request before this litigation was initiated, so August 25th of 2025 was the last request after it had gone through some revisions with the city's responses, and the city responded to that. In that request, the EWU, for example, put a request of in the supplement. So the city has previously provided on the website access to the public to a bunch of information to include the police reports. EWU put on there supplemental 42, which directs you to that supplemental. The surviving roommate's first interviews dated 11/13 of 2022. And the city's response was the city was unable to identify a specific responsive record without additional information from EWU, and actually requested the officer's name and or the initials of the individual, amongst other things. And when you open up that supplemental 42, I guess I'm wondering, how was it difficult for the city to identify the specific responsive record to that?
I think that the answer to that, Your Honor, is just that without listing the names, the location, the time of the records requested, the city can't just go through the 58 terabytes of information that are that the city has relevant to this investigation. And so this without specificity, this isn't a discovery proceeding, and the city needs that specificity to determine what exactly is being requested, i.e. names of the officers, location, times, etc.
I guess I'm wondering, because I think if I recall, if you pull up that supplement off the webpage, it's 4 or 5 pages, and then it is an interview with 3 different people. So I guess I'm on top of that, Mr. Jones, I'm wondering, the city provided declarations. Clearly, there's a lot of information in this case. No one is disputing that. But there's also, it looks like there's been a situation where the city, I think the language was essentially that other agencies or have often just provided information or dumped the information without it being really categorized, or so it makes, in some way, the readings of those declarations make the court question at this point whether it has been categorized, whether the city even knows all of the information that it does have, which then would make it, understanding the burden is on the requester, which is EWU, but wouldn't it make it very challenging for a requester to request information if the city doesn't know what it actually has, because there's so much information? Do you see
Yes, I certainly see Your Honor's point. I don't think that if this were a discovery proceeding, we would be having a different conversation, but this is a Public Records Act proceeding. And so the onus is really on the requester to specifically request the information that it's seeking. And if the requester doesn't know what information it's seeking, and it just wants a broad category of information, that's not an appropriate request. That would be an appropriate discovery request, but it can't just request all surveillance footage and expect the city to go outside the 4 corners of the request and try to determine what exactly the petitioner is seeking. And so there is a little bit of this is an unusual situation. In most public records requests and most public records situations, this wouldn't occur. But given the volume of information in this case, the city can't just spend all the time searching for unspecified information.
And I appreciate that, understand that. I guess I'm just a little troubled by some of the, again, in the records request or records log, you have 2I, EWU requested from supplemental 271, which is provided on the city's website. They narrowed it down to an interview with initials KD dated April 12th of 2024, and an audio CD item 876 as specifically referenced, but the city saying we're unable to identify a specific responsive record without additional information. I guess the question is for purposes of the statute, I think the language is pretty clear as far as them providing the specificity to allow the agency to reasonably go about finding the document. And so I guess I'm wondering if how more specific does a person need to be, or an individual or an entity need to be in requesting, and what is the consideration of the reasonableness? Now, I understand in this case, does the court take into consideration also reasonableness in the sense of the amount of individuals who've been working on for the city who've been working on this? There being, as I understand it, 2 full-time people, the clerk and the records custodian, or the individual, Mr. Smallridge, working at evidence custodian, primarily being the ones who are trying to find or locate or provide or produce this information. But I suppose my question is that does that or should that stand in the way of the city being able to provide it?
I guess I'm not quite sure exactly what Your Honor is asking. I'll just sort of summarize it as there is a litany of requests here. Appendix A has really, really narrowed that request, but we haven't been reviewing Appendix A. We've been reviewing the declarations and the petition that make us we really have to squint at those to determine what is being requested. And even that is taking a lot of effort, and I would submit that it's more than reasonable effort to determine what is being requested. And the question of when is at the time of the request, not at the time of the hearing after we've sort of nailed down some of this information. And so the city has not been able to respond to the requests generally with reasonable effort because of the lack of specificity in the requests, again, on August 18th at the time of the request.
All right. Thank you, Mr. Jones. And then I guess to follow up on my initial question from the beginning of the hearing then, based upon this argument, would the city be asking the court to kind of disregard Appendix A, but go off of what was requested, which is from the, as I understand it, would be the August 28, 2025 request, make its decision based upon that?
So I think legally the court is obliged to make its decision based on the August 18th, 2025 request. From a practical standpoint, we appreciate that it's narrowed down, but that's not what was briefed. That's not what was prepared. That's not what was argued up until last Friday. And so, had the petitioner presented that information, frankly, prior to filing his petition or any time during the pendency of this case, rather than less than a week before the hearing, we may have had a different conversation with the petitioner, and we may be having a different conversation today. But I do think, to answer your question, I appreciate the practical nature of just responding to what's being requested, but legally, we're looking at the August 18th request.
Right. Thank you for the clarification. You may continue your argument.
Thank you. I'll move on to the question of unwarranted invasion of privacy. Idaho Code 74-124-1C provides an exemption from disclosure for materials that are an unwarranted invasion of privacy, and that's defined in 74-101-17A. There is not a lot of Idaho case law determining what an unwarranted invasion of privacy is, which is why the city pointed to federal case law. The city reasonably relied on that federal case law based on guidance, frankly, from this court in Laramie, which also relied on federal case law to determine what an unwarranted invasion of privacy is. And I just say that to address sort of the attorney's fees argument later on down the road. In any event, the petitioner submits that this decision has been made in the Laramie case as res judicata, and that res judicata applies to what is an unwarranted invasion of privacy. And that's not exactly applicable here, because the Laramie case focused on a couple of specific named litigants. And in fact, the petitioner objected to the standing of the interveners to discuss anything outside of those specific named litigants. They didn't object to the standing of the city to address those matters. And so the Laramie case was actually a very narrow decision. And one of the takeaways from the Laramie case is that once this information is disclosed, we can't get that back. And so should the court find that there is an unwarranted invasion of privacy, and that all of these surviving roommates, surviving family members that weren't litigants in the Laramie case, not to mention anybody that was caught up in the scope of the investigation who disclosed numerous private details, including, their addresses, their names, their whereabouts on this day, all sorts of private information. They have an interest in their own privacy as well. So we point to the federal cases, because the federal cases, there's a fair bit of case law examining what this is, and there's also a balancing test. And that's why, similarly with the balancing test, that's why we point to what the petitioner's motives are, because it's relevant to the balancing test and is relevant to the privacy interests of the individuals who are not litigants in the Laramie case. And we submit that the balancing tests rests in favor of the of protecting the privacy interests of the individuals who participated in this investigation. And again, Chief Dallinger's declaration goes into the nature and the wide net that was provided of information that was provided in this. And it's our position that those privacy interests are paramount in this specific case relative to the interests of the petitioner. With respect to the custodian of records argument, Your Honor, Idaho Code 74-103-1, it provides that only the custodian of records needs to respond to a public records request. And then it defines custodian of records as the person with custody and control of the records. It's our position that the city doesn't have control of the records, and the agencies that created the records are the ones that have control of these records. And I outlined in our brief as to why that is. But significantly, the city didn't, it's the prosecution that used these records. It's the prosecution, which is not the city, that was compiling these records for the purposes of prosecuting Mr. Kohberger. And the city was just working with the other agencies in compiling the records. And to use the example of the city police officer going to Pennsylvania to conduct an investigation, the records that were created by the Pennsylvania police are Pennsylvania records. The records that were created by the FBI are FBI records. Any police reports, if the Idaho City of Moscow officer had a body camera and he created those during that investigation, those would be Idaho records. But essentially what the petitioner is doing here is abrogating both state and federal law for the out-of-state agencies by simply requesting these records in Idaho. And it's our position that that's precluded because, one, the city is not the custodian of these records. They don't have control over these records in the way that is contemplated, but also because Idaho Code 74-104-1A provides that records are exempt from any federal or state law, if they're exempt by any federal or state law. And of course, nobody's arguing that federal law is not explicitly worded in that statute, but we're certainly arguing that state law says what it means, what it says, which is simply state law. And of course, I point out that later on in that same statute, it provides the Idaho Supreme Court. It doesn't just say the Supreme Court. And so I think that distinction there is telling. The federal records, the federal law does apply. The Pennsylvania and Washington state law also does apply because of 74-104-1A. And the petitioner provides a little bit of a chicken or the egg argument in the sense that they argue that for example, the right to know law out of Pennsylvania only applies to Pennsylvania. Well, we are talking about Pennsylvania records here. And so because these are Pennsylvania records that were generated in Pennsylvania that that are governed by Pennsylvania laws, the court should consider that not because of the Pennsylvania laws, but because the Idaho Code contemplated that. And similarly with the FOIA argument, these records are probably not disclosable under FOIA with the exemption 7, exemption 5, et cetera, the ones that are listed in the brief, the Privacy Act. And because the Idaho Code contemplated federal exclusions, including FOIA, the FOIA applies. Now, the petitioner points to Magic Valley to hold that FOIA doesn't apply, but that's not exactly what the Magic Valley case says. The Magic Valley case specifically focuses on the question of whether or not names are personnel records, and it's specific and it's narrow to that question. And the Magic Valley case holds that had the Supreme Court, or sorry, the Idaho legislature choose to include names as personnel records, they would have done so specifically in the personnel records exemption, which is not what we're discussing here. So it's our position that the Magic Valley case is inapplicable to this argument. Moving on to the fees question, in the brief, essentially the petitioner is saying, well, we'll pay the fees. Well, this brings us back to the top where we don't know what the petitioner is requesting. And so we're having to anticipate essentially what's being requested in this briefing. And it's our position that Idaho Code 74-102 provides that it's appropriate for the city to require fees in order for to respond to the requests. And on the eve of the oral argument, the petitioner says, "Oh well, we'll pay the fees." I mean, that could have been and should have been done at the time of the petition or at the time of the request. So the refusing to disclose that information because the fees at the time of the refusal of the withholding of that information is appropriate, and it just kind of brings us back to the top that until the Appendix A was provided, the city really had no clear idea of what was being requested. Finally, regarding attorney's fees, we would just simply submit that this was not, that attorney's fees aren't appropriate under either statute. The city's not trying to obstruct justice. The city's not trying to inappropriately withhold information. The city's trying to protect investigative processes of law enforcement. The city's trying to protect privacy interests of persons that aren't parties to this litigation. The city's trying to make sure it doesn't err on the side of providing information that can't be brought back that probably should have been withheld. And so the city's not obstructing anything really. We're trying to comply with the code, and frankly, this is just one of those cases that needs judicial guardrails, no matter how the court decides. And so with that, Your Honor, I'll submit.
Thank you, Mr. Jones. Mr. James?
Thank you, Your Honor. Leander James on behalf of Karen, interveners Karen Laramie, Stacy Chapin, James Chapin, and Maisie Chapin. Ever since, Your Honor, ever since the court entered its judgment granting in part the permanent injunction in the case of Chapin v. et al. v. City of Moscow, LATOC case number CV 292507555, I felt like kind of like the little Dutch boy with his finger in the dike, trying to reasonably and under the statute prevent dissemination of information that is harmful to my clients. I think the issues were very well briefed. The court will note I didn't write a supplemental brief because I felt the court had sufficient information. And I also had been in contact with Mr. Jones and with Ms. Kennedy at some point along the way. So I was aware of what they were going to say. But I do have some additional comments here that maybe will add something meaningful. First, the impact of the release of information on privacy rights. Petitioner argues correctly that EWU's business model is irrelevant to the case. And I say correctly insofar as you look at it from the point of view of the court under Idaho's FOIA, Idaho Code 74-101 at sequence, is not to consider what the information is going to be used for. However, that logic does not carry forward when the court is to analyze the unwarranted invasion of personal privacy. And here's what I'm saying. I appreciate the court under the FOIA may not consider what the requester intends to use the information for. However, the court and the city are duty bound under the statute to determine whether that information being disseminated will result in unwarranted invasion of personal privacy. And the court has already seen in the prior case, the Chapin et al. Case, that the use of this information results in severe and permanent detrimental impacts to my clients and likely others. And that can be considered by the court. So to give sort of a raw example, I understand that not this court, but another court released autopsy records. I think they were already out there. And somebody used those with AI to try to generate images, gruesome images. And what I'm saying is the court should consider, and the city should consider, how this information out there will impact the unwarranted invasion of personal privacy. With that, I'll move to the new snag. It's a new snag here, I think, that has not been addressed. On July 27, 2026, and by the way, I would have briefed this, but it just happened. On July 27, 2026, in Ada County, case number CV 012615-094, and pursuant to Idaho Code Section 19-4901 through 19-4911, the convicted murderer, Mr. Kohberger, filed for post-conviction relief. It's imperative that that case proceed uninfluenced by the public disclosure of information. This is an entirely separate analysis, but it impacts, I think, what we're doing here today. In the underlying criminal case, this court and the court of the Honorable Judge Hippler previously entered non-dissemination orders based upon the court's inherent authority to manage criminal proceedings and protect the defendant's constitutional rights to a fair trial. This court's ruling was later affirmed in Associated Press v. 2nd Judicial District of the State of Idaho, County of Latah, 172 Idaho 113, 2023 case. And the court stated, I'll quote here because I think it's very relevant to frankly both analyses. The Supreme Court said, quote, "We recognize that our trial courts have an increasingly difficult task in balancing the Sixth Amendment rights of a defendant with the First Amendment protections afforded the press. With the advent of the internet and social media, the balancing act has become even more challenging today than it was in the 1960s and 70s, when Shepard and Calder were decided. Although these are well-guarded rights, those seeking to enforce them must still bow to the jurisdictional rules and procedural channels litigants are constrained to follow," unquote. And that's at Associated Press at page 124. The same logic is now triggered here. In his post-conviction relief case, Mr. Kohberger and his court-appointed attorney, which he now has, will likely argue that new information has been dug up by online sleuths, conspiracy buff, and others that are using this information that is being disclosed to then contact potential witnesses to, in fact, in some cases, harass the witnesses to find information out that they can then use to their economic advantage through blogging and so forth online. This is a new cycle. This is why, and I do belabor this a little bit because I think it's really critical. This is a new era we're in, and it's really unprecedented. We're dealing with something that this court has already set a precedent. I think that has rippled through, I know, other states, including Nevada. And the difficulty here is, and the tension between the Sixth Amendment and the First Amendment, are that this information gets disseminated, then it's thrown wide and far. So-called real crime sleuths and investigators and media then contact witnesses in the criminal case and influence these witnesses, and then they create conspiracy theories and so forth, and the court knows this in detail, I'm sure, that then turns around and can be used by the convicted murderer to then seek post-conviction relief. And I want to point out here, I'm not arguing Mr. Kohberger's rights, but I am arguing the integrity of the system. I think what has to be considered is, as this information is let out, it will be used by the media in a way that can negatively impact the post-conviction relief process and the potential that it would be sent back for a new trial. And we've got a real mess on our hands because we've got just this deluge of information. The dam is broke and the information is out there, and it could very well corrupt the whole process that is still going on in the post-conviction relief process and the potential for a new trial. And looking at the appendices that petitioner provided, I see numerous references to witnesses and wanting unblurred faces and information about witnesses. Well, they're going to go contact these witnesses. And when you contact witnesses, you influence witnesses. And what then happens if the reality occurs that Mr. Kohberger prevails in his post-conviction relief and is sent back for a new trial? For all the reasons the court entered a dissemination order in the underlying criminal case, all of those reasons are now present here to prevent further dissemination of anything, for that matter. And I know it's difficult, and it's always hard to bring a new argument up at oral argument. And it just happened. It just happened. The timing was. I mean, I've been dealing myself with a deluge of media trying to get at my clients once the post-conviction relief was filed. I've been spending hours and days fending off media. I'll tell the court, as an officer of the court, it's been very difficult. And it's my honor to do so, but it's difficult work. I literally have to worry about media showing up at my client's door. So in sum, Your Honor, I believe under the FOIA analysis, the court and Moscow, the city of Moscow, are duty bound to protect the privacy rights of not only my clients, but the witnesses and all involved. However, I submit that it's an entirely new analysis now that we have the post-conviction relief case pending that warrants a non-dissemination order equivalent to what the court previously did in an underlying criminal case until that process plays itself out. Thank you, Your Honor.
Thank you, Mr. James. I'm going to just switch back to Mr. Jones to see Mr. Jones before I hear lastly from Ms. Kennedy as a reply. But Mr. Jones, given what Mr. James has brought up here, do you, no obligation here, but do you wish to add anything further on your argument at this point in time?
Only that we would join in Mr. James's arguments related to the petition for post-conviction relief.
All right. Thank you, Mr. Jones. All right, Ms. Kennedy, reply.
Thank you, Your Honor. I just have 2 points I'd like to address in reply. The first is on the broadness or the narrowness of the request, however you want to see it. But Idaho Code 74-1029 does allow for the parties to have a dialogue about what records are being requested and to get more information about those records and to narrow the request. And that's exactly what happened here. And by the time they got to the August 28th request and the September 15th denial, it was very clear what records were at issue. And what records were available and what had been denied by the city and why. And when we originally filed this case, it was very clear that the denials were based on custodianship, foreign law, and privacy. And so regardless of what documents were or weren't at issue, the exemptions that we were dealing with were very clear. The city made that very clear in their denials. And so I don't think that the city can say that we were prejudiced or we didn't understand what the issues were. Even if the particular documents at issue were fuzzy, we were very clear by the time of filing what the exemptions at issue were. But again, the statute does allow the parties to have a dialogue and then to come to a resolution. And if you look at the September 15th denial, it's very clear what EWU was requesting and what the city was denying and why. And then my second point related to the post-conviction relief. I mean, I'm coming into this a little bit cold. I have not seen any briefing on this issue. And so I would object to the court considering that when we haven't had a chance to research or brief any of those issues. But I think we have to go back to the statute and the case law. Wade v. Taylor says that the justification for the denial is assessed at the time of the denial. We didn't have this post-conviction issue at the time of the denial. That wasn't out there. But importantly, in Wade v. Taylor, there's no categorical denial of investigatory records. You don't get to just say, well, the case is open again, therefore you get nothing. The city has to show a reasonable probability of harm for every single record. And at this point, they've already released a lot of records in this case, and we can't pull back all of the records that have already been released. And so they would have to show, the city and the interveners would have to show that, well, for each of these records in Appendix A, that there's a reasonable probability of harm. And I suppose the harm that they're raising is fair trial. So they would have to show, well, you can't have that record because it might prejudice the right to a fair trial. But we have to also look at reasonable probability of harm. Is there a reasonable probability that the petition would be granted such that there would be a trial? And so I think the court would have to look at that. And the interveners, I don't believe, have standing to protect the defendant's right to a fair trial. I think that would be something that the city or the defense team would have to. So with those two issues, unless the court has questions, those are my comments on reply. Thank you.
No further questions. Thank you. I appreciate council, your briefing in this regard, and also providing the records logs provided by the city and the most recent addendum. That just helps for the court clarify, given the volume of records that clearly was cited to in the declarations and the amount of information. It helps the court to narrow down what we're actually discussing or deciding in this particular case. The briefing was very thorough and helpful for the court. Even if we have kind of limited case law on certain things, it's still helpful for the court in guiding it into hopefully getting to a decision. And I appreciate your professionalism and your arguments here before the court. We will take the matter under advisement and issue a decision. Is there anything else in this matter for today, Ms. Kennedy?
No, thank you, Your Honor. We appreciate your time on this case.
Anything further, Mr. Jones
No, thank you, Judge.
or Mr. James?
No, thank you, Your Honor, for your close attention to the matter.
Yes. All right, thank you. We will be in recess for today.
Oh my God. I don't know. She's going to, I don't know how much time she'll take, but she's going to find a way to side with the city. I put money on it. I'll put money on it, but we're going to review. What did someone came in with a comment and I'm like, oh yeah, Blue Devil. Here comes the however. Yeah. Yep. So I told you guys, she gets you hyped up, the judge at the beginning, like, oh, she's being so reasonable. Oh, she's being so, here. And then you all caught the moment. I saw your comments in the chat. I'm like, there's the pivot. Yeah. So, all right, I'm going to go over the points that we heard. How about, let me jump to the Laramie attorney, going right for the online conspiracy theorists, right? Oh, we're just making money. And he cannot make a blanket statement that just because we find out witnesses' names that we're going to automatically contact them. No. You can't make that assumption. I've never done anything like that. So, trying to use the appeal as a way to say, well, he needs a fair trial. If you put this stuff out there, then Bryan wouldn't get a fair trial. That's not your reason. We're saying the opposite. Put the stuff out there so he can get a fair trial. And Witchy had the best, one of the best points earlier that, how did you say it? How do we know? Because here's what the city of Moscow kept saying. You can't say you want all surveillance footage as an example. You have to specifically say, I want the, specific address, specific camera, specific times. And, otherwise we don't know what you're looking for. And Witchy's point was, if they're hiding stuff, how do we know what to ask for? Right? And I think that's why you have these experts coming out like Turvey and Whitcomb's book and Cyray, and they're coming out and they're, whatever your opinions are on those people, stating things that I feel like we've been able to say, oh, there's stuff in there we didn't know about before. Right? So what else is out there that we don't know about? And how about how hard are they trying to hold on to that interrogation video? They do not want that thing released. That's crazy. And it's very telling. It's very telling. And I loved EWU's response to that. She was like, I say that all the time. Be proud of your work. Be proud of your work. What are you hiding? You should be leading with that. Oh. Okay. So one thing is they were disputing the date of the request. Okay. So it appears that EWU has asked several times for a records request. They said the most recent was August 28th of 2025. So almost a year ago. So almost a whole year ago was the last request. And then EWU must have been like, that's it. Hi, Becca. That's it. We're suing you. They must have got their response and was like, we're suing you. So then the whole trial process, legal system takes over. And apparently at the last hearing, I heard, and I can go back and pull it up and play it, but I heard the judge order the city to come up with a list. They were supposed to come up with a list of their stuff in evidence. What do you have in evidence? They didn't have a list, you guys. They didn't even know what they have in evidence, apparently. That's what they claimed. And so the judge was like, well, then we can't have this hearing today. We need to postpone it. That was their whole reason for postponing it. Where's that list? We need to FOIA that list. I thought I heard someone say they were going to FOIA it. Where's that list? Because put that list out to people, right, Witchy? And then we can say, oh, what do you have? What do you have? But he's still saying, we can't just go look for, every surveillance camera. We don't know where that's at. Well, why? That's a you problem. That's a you problem at your city department for not organizing your stuff. But we all know you didn't organize it because you didn't want to play nice with the defense. Like, we all know that. An index. Yeah. She didn't ask for the index. They didn't reference the index. I have not looked at every single thing on Kathy's Indie Zones page. Do any of you know if she has found that or talked about it, or let me jot that down. We need to, what happened to that index? So that's why they postponed this hearing, because Moscow needed all this time to create that index. Okay. So apparently the defense, and I didn't know this, EWU, they went back and they made an appendix, like what do we want to call it? Appendix? I don't know the correct word. They changed their original request and they narrowed it down. We heard them say that many times. Appendix A, they called it. So EWU said, let's make this simpler for them. Let's make it simpler. Thank you, Sleuther. Yes. And so I believe if that's part of the chart that I showed you guys at the beginning of this, right? It was a simple chart. It was very specific. It was very specific. It was like, I want this interview. It's referenced in this report. Maybe it has these initials, or maybe we know the name of the person, so we give them the name of the person. And then I told you guys one of the tricks that I have learned anyways for these FOIA requests is if there's an audio recording, many times, not all, because I've seen some that didn't have it, but many times they will have a number, a file number associated to the recording, and I will include that too. And it sounds like EWU did that, and they still said, "Oh, we can't find it. We can't find it." I don't know, ridiculous. So let's see. All right. So EWU said that we're going to address 3 issues with exemptions. Okay. So all the reasons that Moscow is saying, we can't give that to you. We can't give that to you because we don't have custodianship. That's a big one. They say that there's so many of you, like, haven't seen Accomplished Day in here yet, but anybody who has put in a FOIA request will get a response that, we don't have that. The FBI has that, or we don't have that. Washington State has that, or we don't have it. Idaho, you get the gist. EWU was very clear that it's your case and you were using those other agencies to help you. It's not their case. It's your case, and they were assisting you. So if they did an interview, they were doing an interview because you requested them to do an interview. If they went out and collected surveillance footage, it's because you requested them to do surveillance footage. I thought her argument was very clear, and I do not think that they argued against that very well at all. She said that that is not an exemption. Moscow Police Department had control of the records. So, and then the judge interrupts her. Then the judge interrupts her and says, so let me give you an example, because they were talking about that interrogation of Bryan Kohberger. And she was saying, if Brett Payne was not there, if nobody from Moscow Police Department was there, and the interrogation was done in Pennsylvania, doesn't that put Pennsylvania in control of it? And I think the argument back to that was, no, it's your case. You're requesting them to do that. They gave it to you. They ultimately gave it to you. They're not holding it still. So it'll be interesting. I think she's going to side with the city. And if she does side with the city, I'm sure you can appeal, right? This is probably going to go on for a while, I would imagine. And EWU is not going to give up. I don't see them giving up. I think they do this on principle. Like, they'll do it just on principle, because this is what they believe in. They believe in the freedom of information. It's a constitutional right. Our government can't hide stuff from us. But her using that, I put laugh out loud on my paper. She said, if Payne wasn't there, do they have to disclose it? The judge literally said that. I need to clip that part. Oh my gosh. Bob won't give up. Is that one of the main guys on EWU? I got to go watch them. I don't know the people. How about this shocker? Idaho is more open with their FOIA requests than Pennsylvania. I was like, what? I look at Pennsylvania. I know they're a Commonwealth, so maybe that makes it a little bit different. Oh, Bob is the dad. Okay. I don't know. I was shocked by that. I was very shocked by that. Let's see. So that was all about the custodianship. Let me see what their response to that was. When talking about custodianship, the Zach guy, I forget his last name, Zach was like, he just kept talking about they're too broad. He really didn't address the custodianship part of it. I really don't think he had an argument. I don't really think there's an argument like that. Oh, the judge piped in also during the city's response about custodianship. And the judge said, here's an example. If EWU asks for supplemental 271, an interview with someone's initials KD on April 12th of 24, the judge asked, isn't that narrow enough for you? I liked that. That was a good question by the judge. I liked that. And his response was, well, we weren't looking at that. We weren't looking at the very narrow Appendix A. We were looking at the very broad first one that they gave us. That's not an excuse, Zach. Do your homework. They were making, so he claimed we were making all of our decisions on he even said August 18th date. So he was that's an excuse to me. He was just using an excuse. That's my opinion. All right. The second exemption was they called it a foreign place, and that's where the whole like, well, that's Pennsylvania, they're in charge of it, you know. Oh, their laws, like if you look at Pennsylvania law, they're saying they won't release it, they don't release that stuff, so we have to follow their law. And EWU was just like, no, we're talking about Idaho, we're going to follow Idaho's laws, right? And she said the only exception to that would be a federal law regarding privacy, like personal information, or HIPAA, medical and academic records, right? Sleuther, they were looking at, there were 3 dates. There was August 18th, I guess was like the very initial one. I don't know what that looked like. And then EWU said August 25th was their last final request until they did the appendix. So everybody should have been looking at the appendix. Yeah. Hide what really happened. Let me see. Then they started talking about privacy. And I loved EWU. She said that I was surprised by this. She said they overly redacted the bedrooms. And I think even when you look at like Dylan's bedroom, I mean, unless there's something in there, like an open personal diary, or I don't know, they were redacting photos on the wall. That's crossing the line. That's crossing the line. Nobody wants to see, I don't want to see the victims. And she said there were more redactions than there were bedrooms. Something like that. Oh, and there was a big deal that EWU made that you can't discriminate based on the requester, right? Just because we're not Netflix trying to make a movie or a family member, you cannot, that's law. You can't discriminate against that. And which is interesting that the Laramie's lawyer came right back, and that's exactly what he started talking about, like discriminating against social media people from reporting information on the case. Reporting information on the case, and if I were to clap back to him about that, about him saying, oh, conspiracy theorists, the more you hide, the more we're going to speculate. It's a natural cause and effect. When you cause an effect, when you hide things, you only leave it up to interpretation, right? Give us the facts, and then we would look like idiots if we went out there running around with crazy stories. I mean, I try not to run around with crazy stories as it is, but you get my point. You get my point, right? Oh, there you go, which he was. So that's very private, personal information about Kaylee that was not redacted. But then, we can't see drawings on the wall above a toilet. Remember, they redacted the pictures above the toilet? Yeah, why is the spare bedroom redacted? Like, that's not even associated with anybody. So even if we saw something in there, we wouldn't know whose it was. Yeah, great points, you guys. Great points. So those were her 3: privacy, the foreign places, and custodianship were her 3 arguments, basically saying, we asked for stuff. Moscow said no, because we're not in charge of it. You're asking for something that is private, or you're asking for something that can't be released because Pennsylvania law doesn't let you release it. Like that's what I heard EWU claiming and speaking against. So, and then I was glad she didn't go into the cases, but that EWU attorney was lined up, ready to go with a court case to defend each of her arguments. And so she wasn't just arguing, she was like, Judge, for the custodianship argument, I have this case. For the foreign, I don't know the name of that. For the foreign place, I have this case. And for the privacy, I have this case. So she was very well spoken and prepared. And I thought she made her arguments perfectly. Then they asked for the, there's always going to be a battle over attorney fees, right? So that was in there. Then, when Zach Jones, is that what you guys said? Zach Jones, like I said, he went right into, it was too broad, that whole thing. But see, excuse me for a second. Here's what's going to happen. Here's what's going to happen because the judge did it last time. Zach Jones said, we were looking at the August 18th date. It's too broad. We weren't looking at the new appendix. And the judge is probably going to come back and use that. I'm telling you, she's going to find some nugget. She's got to find some nugget in there that she can side with. I don't know if that's going to be the one, but it might be. We already talked about Laramie coming back and talking about, he just threw I even wrote down how he called it. He called it a new snag. We're going to talk about a new snag in the case. And it was Bryan putting in for his post-conviction relief. How's that going to affect the case? And I loved EWU's response to that. They were like, that needs to be tabled. She didn't say it like that, I don't think, but basically that's what she meant because we haven't been notified of that. We haven't had time to research anything about that. So I really can't responsibly address that right now. So she was basically saying that that's shouldn't be considered. We object to this. She literally said the word object. We object to that. So that was good. That was good. Laramie was saying that it would be obstructing. It would be obstructing the new case. So if you allow these records requests, you're going to obstruct Bryan's. And we're out here going, hello, that's the opposite. That's the opposite. You would not be obstructing. You would not be obstructing. Let's see. And just to end, the defense just reiterated that the privacy law is not that specific. They are placing, they are claiming that there is an unwarranted invasion of privacy, that there's not. She's saying, no, there's not. We're not doing that. We're not doing that. She said you should not be concerned with requests with what our motives are. Whatever we're doing is none of your business. We have a right to the information. Right? Yeah, how many documentaries has there been? Yep. No judge has issued a stoppage of record. Well, one thing that I did hear, I didn't write it down, but did EWU make the point that it should only be the records custodian who responds to FOIA requests? Didn't she say that? And I was like, I got a response from the attorney. I'm sure I have it saved. The attorney responded. I don't think they're allowed to do that. And see, those are the things that I think EWU needs to know. There's so much more going on. 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 There's Yep. Oh, and then they kept citing a Laramie case. I don't know what that is. I'm going to find out about that because they kept talking about it like it was important. I need to find out what that was. When they said that Dollinger made a declaration, I was like, what? He has a declaration in this lawsuit? We need to find that. I need to find that. Oh, the other thing, I don't know if you guys caught this, but I caught it because I have been saying this for a long time now. EWU said that if MPD denies, or no. She said if MPD makes a redaction, then they need to explain every redaction. That's in the law. I started to do a show on that. I think it was like 2 Fridays ago. I found a bunch of information about FOIA requests. I need to dig that back out and share that with you guys. Like, I'm going to do that. I haven't gotten a FOIA request yet, but if that happens, I'm going to put in a request and say, please cite a reason for every redaction. And they have to do it. That was the case that made them not able. Oh, the new privacy bill. I got you. The new privacy bill. Yes, got you. Because blood is a body part. Oh my God. Oh my goodness. Oh my goodness. So the next time I have a bloody nose, I'm going to say a body part's coming out of my body. When we get a paper cut, we're going to go, oh my God. What are we going to say? What's a phrase for that? We need a t-shirt. Blood is a body part. That's crazy. That's crazy. I mean, just think of the women. You know how we fight against that? This is how my mind works. I'm such like a social justice person. So women, wink, wink, you know what I'm talking about. I'm not excluding you men. We want you as allies, but you don't go through this. With monthly cycles. So calling blood a body part. What could we do with that? What could we do with that? There's got to be something we could do with that. Like to turn it. So they're like, oh my God, we can't call blood a body part because women are going to like profit or benefit in some way. Because we all know they don't want that to happen. We need to brainstorm. How can we flip that? Yeah, right? It's a good question. You lost a body part at the post office a week ago. Oh my God. Hashtag body parts. Oh, there's always something. Let's see. I think I covered everything. Oh, they tried to fight back. The defense. He tried to fight back and say like, EWU said the custodian should be the only one responding. And he said, but the prosecutor's the one that was compiling the investigation. I didn't even understand his response to that. Like it made no sense to me. Oh, he was trying to say that Moscow is not the custodian. Oh my gosh. And he better watch that because what if we're like, okay, Moscow's not the custodian. Who is? Fingerprints or body parts? I don't know. Oh my gosh. Let's see. I didn't know I had another little. Yeah, I think we hit it all. Your touch DNA has been shipped to 103 countries in the past 5 years. You're cooked. How about, listen to this. How about every time your doctor orders blood work, are they taking a body part away from you? Like you're losing a body part every time you have to go get blood work done. Like I'm telling you, there should be a lot of implications from that. Insurance companies are collecting our body parts. I could go on all day. Carlos is going to shake his head at me. Oh my God. Oh my God. What did Sluther say? Your reflection is your body part. How about fingernails? Yeah. Oh my gosh. We got to stay on the blood though. We got to be able to flip that. Oh, I appreciate you guys so much for hanging out with me and watching this with me, because you guys have the best comments, the best information. We vibe. Like I'll be listening, like I'm listening to the hearing and I'll start feeling a certain way. And I'll look at the chat and someone will like write the same kind of comment I was about to write, you know, or something will strike me funny. And I'll look at the chat and you guys are already like making laughing faces or making sarcastic comments. So that's the best. I enjoy listening, analyzing, breaking this stuff down with you. Thank you so much. I know you had a lot of choices of where you could have gone today to watch this. So I just want you to know how much I appreciate it. I appreciate your time and your energy you guys put in the chat. I love it. Brian Todd. Oh my God. Gas is body parts. That's crazy. Yeah. Thank you guys. I love you all. Receipts. That's funny. So go have a great rest of your day. I know some of you are working and you're still like in and out, and I appreciate that. And I'll see you in the other chats, and I'll be back tomorrow. Mods, if you could look at the mod chat in Discord and let me know if you're available tonight. There's some messages in there. I would greatly appreciate that. Hopefully I'll be seeing you guys at like 6 o'clock tonight. Everybody else, I'll see you back here tomorrow. All right. Clocking out, you guys. Bye.
Thanks for watching, hope you felt the spark. Please hit that like before it gets dark. Subscribe, it's free and keeps us going strong. You're part of the crew now, right where you belong. Join us next time, same truth, same fire. We bring the heat and never tire. We're typically unique and proud to be a husband and wife in podcast harmony. That could be unique, yeah, that's you and me. Don't forget to like and hit subscribe, it's free. Come back again, we'll be right here with truth and laughs and zero fear. We don't always agree, but that's the show. One love, two minds, letting it flow. We dig deep with crack jokes, we call it like we see. If that's your vibe, you belong here with me. We don't always agree, but that's the show. One love, two minds, letting it flow. We dig deep with crack jokes, we call it like we see. If that's your vibe, you belong here with me. We don't always agree, but you felt the spark. Please hit that like before it gets dark. We dig deep with crack jokes, we call it like we see. If that's your vibe, you belong here with me. Thanks for watching, hope you felt the spark. Please hit that like before it gets dark. Please hit that like before it gets dark. It's free, it keeps us going strong. You're part of the crew, now right where you belong. Join us next time, same truth, same fire. We bring the heat and never tire. We're typically unique and proud to be a husband and wife and wild to be a husband and wife in podcast harmony. Yeah, that's you and me, that's you and me. Don't forget to like, hit subscribe, it's free. Come back again, we'll be right here with truth and laughs and zero fear.